Good afternoon, ladies and gentlemen. Once again, my name is Patrick Richard. You see me every day for the past week and a half. When I first spoke with you, I told you that this was not a case of advanced mortgage management. There was a case of a woman trying to protect her property from the divorce that she was going to be going through with Mr. Gordon. I asked you to listen to the evidence, and I told you that I thought, when you heard the evidence, you would be able to return a verdict of not guilty on each and every count against Mr. Gordon. Now, I suggest that there's reasonable doubt as to each and every count that is remaining against Mr. Gordon. Specifically, there were 2 counts here regarding stock. You've heard a lot of evidence, texts, voicemails, allegations that Mr. Gordon came to the home, did damage to property, did things in the statements that put her in fear. Part of what the Commonwealth was proved to you, to prove stock, ladies and gentlemen, is to show that the victim, the statements, was alarmed by what she had heard and what she had seen, and that what was done to her was done with malice, that is, it was done without justification and without motivation. If you looked at the texts and the voicemails and the statements received allegedly from Mr. Gordon, you'll see that what you have on one side, you only see Mr. Gordon's statements, but you don't see or hear the responses. Miss Stamos was up on that stand. She told you that she was trying to, as she said, flush him out, saying some things that would provoke some action by Mr. Gordon. I suggest, ladies and gentlemen, that's some mitigation, some justification as to what Mr. Gordon did and what Mr. Gordon said. So I would say on the stalking counts, I suggest to you that the Commonwealth has not proven beyond a reasonable doubt that Mr. Gordon did do those things. There are also 6 counts which are going to be before you, a violation of restraining. Now, there was a first restraining order that Mr. Gordon was served on June 23rd. It expired in very early July of that very same year. It lasted 10 days. There was a second restraining order, ladies and gentlemen, as we've been told, that was only served upon Mr. Gordon on August 11th. Now, there are numerous counts before you suggesting that before that August 11th date, Mr. Gordon violated that order. What the Commonwealth has to show to you is that Mr. Gordon knew of that order or was given a copy of that order. And I suggest to you, ladies and gentlemen, the evidence that was presented by all the officers, civilian witnesses, that Mr. Gordon did not know about this restraining order until sometime on August 11th. Officer Pulaski from Air Police Department said that he went to attempt to serve Mr. Gordon in the area, but one that was unable to do so. No other officers, no testimony has been shown that other officers were able to serve Mr. Gordon or inform Mr. Gordon prior to August 11th. Now, I'm sure the Commonwealth will remind you that there was a text. No cops, no court, no restraining orders would be away. I suggest to you, ladies and gentlemen, that that's not indicative of Mr. Gordon knowing that there was an actual restraining order and what the terms of that restraining order at the time that he took whatever actions he took in early August of 2008. Now, specifically, as to the court incidents on August 11th and September 10th of 2008, we've heard numerous people testify regarding that event. We've heard Ms. Stamos, who told the court what happened. We heard Officer Belletti of the Berwick Police Department, who told what he saw. Officer Bowler, who told us all what he saw. Ms. Judy Gatto, who said what she saw, what she heard. We heard Ms. Giles specifically say what she saw and what she heard that day. And lastly, we heard from Mr. Gordon's attorney, who was standing right next to him in the courtroom on September 10th, who told you what he saw and what he heard. Now, Ms. Gatto and Ms. Giles and Mr. Carlo testified on this, and that they believe that Mr. Gordon was talking Ms. Giles thought it was to her. Mr. Parlow thought it was to Ms. Giles. Mr. Parlow didn't even know who Ms. Gatto was at that time. But Ms. Gatto thought it was to her that she was being spoken to. She had seen him on a regular basis. They left the courtroom. Ms. Stamos says when she found out that Mr. Gordon was going to be released, looked down at the ground and heard the statement, "I'll see you tonight." The police officer, Officer Belay from the record, said there was no one else in the courtroom, and he saw Mr. Gordon say directly to Ms. Stamos. Officer Bowler said that when he came in the courtroom, there was still a fair amount of people in the courtroom, in that Ms. Stamos was upset. When he interviewed Ms. Stamos, she not only indicated what was going on that day, the fact that she was upset that Mr. Gordon was getting out, but indicated that something happened in August. And on that August 8th, Mr. Gordon, as we know, was in custody of the local district court. But she told the story to Officer Bowler, if you recall, that she saw Mr. Gordon in the hallway of the local district court. I suggest to you, ladies and gentlemen, to balance what you heard. Is it reasonable to believe that something did happen in August? Is it reasonable to believe that in September, Mr. Gordon was talking to Ms. Stamos and not Ms. Gatto or Ms. Giles? I suggest when you balance the evidence, you can come back with a verdict of not guilty as the restraining accounts of what happened in this report. Now, Mr. Gordon is also charged with destruction of property on July 30th of 2008 and August 1st of 2008. On July 30th, tires were slashed on Ms. Stamos' car, and that as the officer McCarthy said, what resembled an M-class explosive device was also unleashed. There's been no indication that anyone saw specifically Mr. Gordon on that day slice the tires or place this device upon the windshield of Ms. Stamos' car. As to that device that was placed on the car, again, Officer McCarthy said it was an M-class device, and that it was it met the description of what could be a 1.3 explosiveness. However, it was not taken to a lab, and the officer could not tell you if it was exploded or if it contained explosives. The officer only said it resembled it. Now, the officer, who is a state trooper dealing with explosives on a regular basis, indicated to the court that these devices are not produced or sold in the United States, that they're made at home by them. Now, one thing the Commonwealth has to show you with the placing of an explosive device is the Commonwealth has to prove to you that that device contained explosives or gunpowder, or that it was a bombshell or a torpedo or some other explosive device. I suggest to you, ladies and gentlemen, that they have not shown that to you. They show that it resembled a device, but could not say to a point where you can find beyond reasonable doubt that that was an explosive device. Now, ladies and gentlemen, lastly, we know that Ms. Stamos' house burned down on November 17th, 2008. Lieutenant Dillon testified that it was not accidental, that this was not a natural thing, that it was actually a set fire. We've heard numerous witnesses, including Ms. Stamos, who said that she had just walked by that area minutes before the fire took place. From where the fire began, according to Lieutenant Dillon, Ms. Stamos would have had to walk by that area right before that fire was set and started. She did not say that she saw Mr. Gordon. I suggest to you, ladies and gentlemen, from the evidence you've heard, Mr. Gordon would have been there at the time that fire was set, and that Ms. Stamos would have seen Mr. Gordon in that area. Now, Ms. Ortiz, Doris Ortiz, testified that she thought she saw a person that she believed was Mr. Gordon. on that night, standing by the fire, and then walk across the street. She said that person had facial hair. I suggest you, ladies and gentlemen, from everything we've heard, from Ms. Gatto, from Mr. Brian Howard, that Mr. Borden didn't wear facial hair at this point in time in his life. He shaved on a regular basis. Ms. Gatto, I believe, said today that Mr. Borden would use an electric razor every single day, including that day. Another person that we heard testify that she thought Mr. Borden was there was Ms. Desiree Gordon. According to Ms. Desiree Gordon, when she arrived home from work, she saw Mr. Borden by the house. She saw Mr. Borden when she left the house to go to the store. She saw Mr. Borden when she came back. She saw Mr. Borden when she went up the stairs, downstairs to do her laundry and came back down again. And then made a comment. And again, she had mentioned facial hair. I suggest to you, ladies and gentlemen, that this did not happen. It was not Mr. Borden. You're entitled, ladies and gentlemen, to decide the credibility of each and every witness. And I suggest to you, especially with Ms. Desiree Gordon, to weigh the evidence given by other people and as these witnesses. I suggest Desiree Gordon, ladies and gentlemen, is someone whose tongue and tail is not the same as everybody else's. Why do I point to that? She also indicated that 2 days prior to her testimony, for the first time, she said that she saw Mr. Gordon and Ms. Stamos fighting sometime during that summer, at which point, the conclusion of the fight, Mr. Gordon went to the car and slashed the tires. Ms. Stamos testified on the stand that at any time that her tires were slashed, she never saw Mr. Gordon. Now, you heard Ms. Gatto testify as to a defense for Mr. Gordon that he was home at around 7 o'clock at the time of the day of the fire, and that he never left the house. She's very hard to hear. That was obvious from being there. But she did testify that she could hear loud noises, sirens, loud bangs, and especially her dog barking. She testified that when her dog barks, it's all the time. That dog barks when anybody goes near that door. I suggest to you, ladies and gentlemen, that she would have heard Mr. Gordon going for that door to leave at any time while he was home. She was positive that he was home around 7 o'clock. This fire started around 7:45. And as the lieutenant said, Lieutenant Dillon, that fire is a fast-moving fire. So it couldn't have smoldered for a period of time. It would have been set within a matter of moments. So Mr. Gordon would have had to have been there at 7:45. I suggest from what you've heard that Mr. Gordon was not there at 7:45. He was not there earlier in the night at 22 Burlington, that he was actually 92 Web Street in the city of Lowell with Ms. Gatto and her son. Now, he's charged with arson, burning a dwelling, also burning personal property, and violation of restraining order on that day, that he was there at that occasion. I suggest to you, Mr. Gordon was not there at that time. That as to those counts of the indictment that allege that on November 17, 2008, Mr. Gordon was at the home on 22A Burlington Avenue of Ms. Stamos, that he was not there, did not do these things. So we ask you to return the verdict of not guilty on those grounds. I've asked you to listen to everything. The court has asked you to listen to everything that you've heard on this witness stand, and I believe we have. And I suggest, ladies and gentlemen, that you'll be able to find that the Commonwealth has not proved the case beyond reasonable doubt, that on each and every count, you can return a verdict of not guilty here today. Thank you. Thank you.